This is a review of BLLE Chapter 10, Real Assent. After reading the chapter, we should understand the following. Contracts require a meeting of the minds between competent parties, and if there is no such meeting, then the agreement is usually voidable. Parties must enter the contract voluntarily without duress or undue influence. Misrepresentation or fraud, when proven, violates a contract. A mistake may make a contract voidable, and parties to a contract must have capacity, that is, not labor under infancy, intoxication, or insanity. As legal scholars, you know that there must be mutual assent coupled with consideration to form a legally binding agreement. Mutual assent is the meeting of the minds or an agreement between the parties. In this chapter, we turn to the first set of defenses to contract formation. In addition to manifestation of assent, a party's assent must be real. They must consent to the contract freely with adequate knowledge, and they must have capacity. Sometimes the party's words or conduct imply that there is a meeting of the minds and there may not be mutual assent. In those situations where mutual assent is lacking, the contract will become either void or voidable. These concepts affect the enforceability of a contract. A void contract is a legal nullity. It is invalid as a matter of law and cannot be enforced by either party. A voidable contract, on the other hand, is a binding contract on one of the parties, while the other party has the option to withdraw from the contract or enforce it. If a contract is voidable, the electing party may rescind or avoid the contract. The requirements for real assent raises the following questions. Did the parties enter into the contract freely, willfully, and with mutual assent? Or otherwise stated, did the parties enter into the contract of their own free will, or was one forced to agree under duress or undue influence? Did the parties enter into the contract with full knowledge of the facts, or was one or both led to the agreement through fraud or mistake? Or did both parties have the capacity to make the contract? Undue influence is characterized as unfair persuasion. It is a mild form of duress. The unfairness is not founded in a misrepresentation. Undue influence is the improper use of trust or power to deprive a person of free will and substitute instead another's objective. Unfairness occurs when the victim is under the domination of the persuader, or is one who, in view of the relationship between them, is warranted in believing the persuader will act in a manner detrimental to the victim's welfare if the victim fails to assent. The general rule is that if undue influence is present, then the resultant contract is voidable by the unfairly persuaded party. The test for this determination is whether the relationship is one of domination and persuasion and is unfair. A determination of undue influence is a question of fact in which the following must be considered: the unfairness of the bargain, the unavailability of independent advice, actions including emotional, psychological, and legal manipulation, and susceptibility of the person persuaded. Common fact patterns include a victim being isolated from receiving advice except from the persuader, a child taking advantage of an infirm parent, a doctor taking advantage of an ill patient, or a lawyer taking advantage of an unknowledgeable client. Duress is defined as the wrongful pressure exerted upon a person in order to coerce that person into a contract that they ordinarily would not enter. Duress involves either an intentional use of physical force or a threat of force in order to induce the contract. Duress may occur physically or mentally, but the coercion must be to the extent that it deprives the other person of free will or freedom of choice. The Restatement Second of Contracts in sections 174, 175, and 176 outlines duress. There are two types of duress: physical duress and duress by threat. Physical duress implies some compelling physical force. Because no mutual assent exists and the seriousness of the duress at law, a contract formed here would be void. Under Section 174, if conduct that appears to be a manifestation of assent by one party who does not intend to engage in that conduct is physically compelled by duress, then the conduct is not effective as a manifestation of assent. This rule illustrates the old law requiring the proverbial gun to your head, or an instance of battery, for example, to justify duress and avoid the enforcement of a contract. In such cases, the party's assent is not effective. The occasions for this type of duress is very rare. Recently, however, duress has been expanded beyond the parameters of Section 174 to include duress by threat if they can show that their free will was undermined by a threat of compulsion short of physical compulsion. Under Section 175(1), if a party's manifestation of assent is induced by an improper threat by the other party that leaves the victim with no reasonable alternative, then the contract is voidable by the victim. Note that because the contract is voidable, i.e. not automatically void, the victim can choose to follow through on its contractual obligations and seek compensation for the wrongful conduct in other ways, like in a tort suit. Section 175.2 continues to state that if a party's manifestation of assent is induced by one who is not a party to the transaction, then the contract is voidable by the victim unless the other party to the transaction, in good faith and without reason to know of the duress, either gives value or materially relies on the transaction. Remember that the unfair pressure required for duress by threat generally falls short of physical compulsion, but nevertheless results in compulsion to enter into a contract. Also, economic duress is recognized as a basis for relief. Pursuant to Section 175 and 176, the following elements must be satisfied. First, the threat must be improper. Generally, a threat is an indication to do something that will inflict harm, loss, or injury on a person's body or their personal or economic interests. The intent does not need to be explicit. It can be implicit based on the circumstances, i.e., the person's words or actions. The threat can also be of a positive action, i.e., I will do this action, or the forbearance from an action, i.e., a negative action. Improper threats may be described as instances of extortion or blackmail and includes threats to commit a crime or tort, instigate criminal prosecution, instigate civil proceedings in bad faith, breach a duty of good faith and fair dealing under a contract with the recipient, and disclose embarrassing details about a person's private life. The second element to duress by threat is that the victim must not have any reasonable alternatives but to comply with the threat. An improper threat does not justify duress unless it leaves the victim with no reasonable alternative but to succumb to the threat. When making this determination, two issues arise. First, as it relates to the victim's emotional state, the issue to be determined is whether or not the victim had the fortitude to stand up to the threat. Under older law, courts looked to whether the threat was serious enough to compel a person of ordinary courage to yield to it. Modern courts, however, take a subjective view. The test is whether, under the circumstances, the duress substantially overcomes the victim's free will, leaving them no reasonable alternatives but to comply. Persons of weak or cowardly nature are the ones who need protection and to which the law applies. An example of this would be where a supplier threatens to hold up a shipment of necessary goods unless the buyer agrees to pay more than the contract price. The second issue is whether the victim had a reasonable alternative. This concerns the exigencies in which the victim finds themselves. If the victim faces financial ruin, then a court may conclude that the victim had no reasonable alternative but to succumb to the threat. And our third element is that inducement is tested subjectively. That means that it doesn't matter that the threatened person is usually timid. It also doesn't matter that a reasonable person would have felt threatened. The issue here is whether the threat in fact induced the victim's assent. Relevant considerations include the victim's belief that the threatener had the ability to carry out the threat and the length of time between the threat and assent. For example, Clown purchases a vehicle from Cheesy car salesman and returns on the next day stating that Cheesy sold him a lemon. Clown threatens to break every window of the remaining vehicles on the sales lot until Cheesy buys back the lemon from Clown at the purchase price. Cheesy agrees to purchase the vehicle back. Here, Clown makes an offer which Cheesy accepts, thus forming mutual assent. The agreement is bargained for since the parties' promises induce a return promise. Thus, mutual assent and consideration are present, and the parties have a binding and enforceable contract. The question is whether the parties entered into the contract freely and willfully. This scenario falls within the duress by threat category because it is not physical duress. This agreement is voidable if the threat is improper, which it is, as it is a threat to commit a crime or tort, and if the salesman feels as though he has no reasonable alternative and is frightened into agreeing. It does not matter that the agreement is fair to Clown. Consider this example. Same facts as before, except instead that Clown says, I know what you did last night. You like to tamper with your car's odometers. That's a federal offense. How about I have you prosecuted if you don't repurchase this lemon? Here, the question is whether the parties entered into the contract freely and willfully. This scenario falls within the duress by threat category because it is not physical duress. The threat is improper because it is one to instigate criminal proceedings. Public policy considers a threat to criminally prosecute to be an improper bargaining chip. Thus, if the salesman feels as though he has no reasonable alternative and is frightened into agreeing, then this agreement is also voidable. It does not matter that the agreement is fair to Clown. Let's change the facts slightly. Same facts as before, but instead Clown says, I'm going to sue your socks off for the purchase price of the vehicle to induce Cheesy's return promise. Here, the question is whether the parties entered into the contract freely and willfully. This scenario falls within the duress by threat category because it is not physical duress. Further, the threat is not improper because it is not a threat to instigate civil proceedings in bad faith. Someone who has a colorable tort claim against another may threaten to file an action, and the threat would not be made in bad faith because it is legitimate. Thus, this threat cannot substantiate a claim or defense of duress by threat. Another example, same facts as before, except the original sales contract states as terms the contract price and a warranty on all necessary repairs, including replacement of parts for the first 90 days. Clown purchases the car. Clown returns on the next day, requesting that Cheesy replace the transmission immediately. Cheesy responds stating that he will not replace the transmission unless Clown agrees to sign a contract to purchase his next car from Cheesy. The parties have formed a binding and enforceable contract because there exists mutual assent and consideration. The issue here is whether Cheesy's threat is improper. Does Clown have a reasonable alternative? If Clown needs the transmission immediately and has no money to pay for a new transmission elsewhere, then he has no reasonable alternative. Thus, the threat would be improper and the contract would be voidable. However, if a replacement is available and Clown has the funds to pay for it, then he has a reasonable alternative. Thus, the threat would not be improper and the contract would not be voidable, but Clown could later sue Cheesy in tort or contract for damages. Another example, same facts as before, including the original sales contract, except when Clown returns on the next day requesting that Cheesy replace the transmission immediately, Cheesy responds that he will hold up the repair work unless Clown agrees to pay for it because Cheesy cannot replace the transmission at 3 times the cost. The underlying agreement is binding and enforceable. The issue here is whether Cheesy's threat to breach the contract is improper under the circumstances. This threat is not necessarily improper. This determination depends on whether the new contract is fair and equitable because of the unanticipated circumstances. Thus, this threat may be reasonable. Real assent may be invalid for other reasons, including misrepresentation, where a party makes a factually incorrect statement to induce the other party to enter into a contract. A person's agreeing to a contract based on a misrepresentation invalidates mutual assent and may render a contract void or voidable. A misrepresentation may be actionable in contract, tort, and criminally. Misrepresentation first arose in tort and later developed in contract law, which is why you may see similar doctrines. Here, we discuss contractual misrepresentation further. A misrepresentation is a statement of fact that is not consistent with the truth, i.e., not in accord with the facts. There are 2 types of misrepresentation to which this definition applies. 1, fraudulent or intentional, and 2, non-fraudulent or not intentional. If a party's manifestation of assent is induced by either a fraudulent or a material misrepresentation, i.e., non-fraudulent misrepresentation, by the other party upon which the recipient is justified in relying, then the contract is voidable by the recipient. A fraudulent misrepresentation is defined as the intentional misstatement of fact on which another party justifiably relies. The Restatement Second of Contracts, Section 162(1), states that a misrepresentation is fraudulent if the maker intends his assertion to induce a party to manifest his assent, and the maker either knows or believes that his assertion is not in accord with the facts, or does not have the confidence that he states or implies in the truth of the assertion, or knows that he does not have the basis on which he states or implies for the assertion. Taking 164(1) and 162 together, we know that if one party makes a fraudulent misrepresentation, contract enforcement can be avoided by the wronged party. The falsity of the misrepresentation does not depend on intent. For example, a typist's unnoticed error in a letter can amount to misrepresentation on which a recipient may rely. Half-truths also amount to a misrepresentation. In contract law, a misrepresentation may take numerous forms, including concealment, nondisclosure, statement of opinion, misstatement of law, and assertions of intention. Each of these is discussed in turn. Concealment is an action intended or known to be likely to prevent another from learning a fact, which is the equivalent to an assertion that the concealed fact does not exist. In other words, a concealment is hiding the truth. It does not need to be direct. So, for example, if a homeowner paints over a ceiling that was damaged by water to keep prospective buyers from learning about prior water damage, the law will treat that action as if the homeowner affirmatively stated that the house never had water damage, which is an obvious misrepresentation because it misrepresents the condition of the property. Non-disclosure is when a party remains silent instead of correcting wrongly assumed facts and is considered a misrepresentation under limited circumstances. Non-disclosure presents special problems in applying the caveat emptor or buyer beware doctrine. Each party is assumed to be looking out for their own self-interest and should probably ask questions to gain information. If they fail to seek out information, then it is their problem as long as they have not been lied to or been given an affirmative misrepresentation. Section 161 tells us when a party has the duty to affirmatively disclose facts in exception to the caveat emptor doctrine. Non-disclosure amounts to a misrepresentation when a. the maker has knowledge that the disclosure of the fact is necessary to prevent some previous assertion from being a misrepresentation or from being fraudulent or material. Also, non-disclosure amounts to a misrepresentation when the maker knows that the disclosure of the fact would correct a mistake of the other party as to a basic assumption on which that party is making the contract, and if the non-disclosure of the fact amounts to a failure to act in good faith and in accordance with reasonable standards of fair dealing. This section is implicated when the party required to disclose may have no responsibility for the other's confusion, but the restatement states that good faith requires a correction. Good faith and fair dealing considerations which may lead to a party not having to disclose facts would include, number 1, the cost to acquire contested information. Here the issue is, did one party incur some cost to acquire the contested information such that it is viewed as their property which does not have to be shared? Fairness does not generally require that this type of information be disclosed. Examples include market trend analyses and consumer panel reports. Secondly, readily available facts also don't have to be disclosed. If the facts are available to the other party due to a diligent search, then there is no duty of disclosure. Where the means of intelligence are equally accessible to both parties, then the party has no duty to disclose. The third way a non-disclosure amounts to a misrepresentation is when the maker knows that the disclosure of the fact would correct the mistake of the other party as to the contents or effect of a writing, evidenced or embodied in an agreement in whole or in part, and it deals with instances in which it becomes clear to one party that the other party has a mistaken understanding of the provisions of the contract, and if one party knows the other party is confused, then that party must correct that misunderstanding. Lastly, a non-disclosure amounts to a misrepresentation when the other person is entitled to know the fact because of a relation of trust and confidence between them. Such relations arise when one party is acting as a trustee, agent, or guardian on behalf of the other party. This section also applies to relationships that do not involve legally imposed fiduciary obligations and includes relationships between doctor and patient and family members. Non-disclosure is a passive concealment which is related to unilateral mistake, a doctrine we will later discuss. Note that a disclosure may be made false by subsequent events, which is construed as a non-disclosure. If a statement of fact is made and it later becomes false by events, then the statement must be disclosed as false. For example, seller tells buyer that he owns 30 acres of land when he really owns 27 acres, but he exaggerated, meaning no harm, since the conversation had no import. 1 year later, buyer offers to buy the 30 acres from seller. If seller does not correct buyer's impression, then seller's failure to speak constitutes non-disclosure. The next way a misstatement of fact may develop is through statements of opinion. Statements of opinion are not generally construed as misstatements of fact. One must distinguish between a party making an affirmative assertion of fact on one hand, and they're merely asserting an opinion or even hyperbole or making a prediction on the other hand. Mere assertions of opinions are insufficient as misstatements of fact and do not establish misrepresentation. An assertion is one of opinion if it expresses only a belief without certainty as to the existence of a fact, or expresses only a judgment as to quality, value, authenticity, or similar matters, including puffery. As such, none of them are expected to be taken as true. They are mere assertions or suggestions of personal judgment, and reliance on either of them is not considered justifiable, subject to certain exceptions, i.e., when reliance on the statement is justifiable and will be construed as a misstatement of fact. Exceptions include when the recipient either 1. Stands in a relation of trust and confidence to the person whose opinion is asserted that the recipient is reasonable in relying on it, or reasonably believes that as compared with themselves, the person whose opinion is asserted has special skill, judgment, or objectivity with respect to the subject matter, or is for some other special reason particularly susceptible to a misrepresentation of the type involved, or otherwise stated, is inexperienced or susceptible or gullible to blandishments and not just merely astute. In any of these instances, a contract will become voidable. Next, misstatements of law may be taken as fact to justify a misstatement under certain circumstances. Assertions about law or legal consequences of a given set of facts made by a layperson is generally held to be an opinion on which the recipient will rely at their peril. For example, if there is a lien on a corporate building and seller states that the courts will throw it out and that the buyer won't be bothered by it, then this is an assertion of a legal opinion made by a layperson and is not actionable. However, if the statement of law is made by a lawyer, real estate broker, or some other person on whom a layperson may justifiably rely, then it may be taken as fact. Under those circumstances, if that fact is untrue, then this would form the basis for a claim for misrepresentation. For example, a court clears title to a parcel of land. That is a statement of fact. If it is false, then it is governed by the same rules that govern a misstatement of fact. Note that statements about foreign laws are generally held to be statements of fact, not opinions. Lastly, although assertions of intention are not generally construed as facts, if an assertion of intention is false at the time it was made and the assertion is harmful to the recipient, then, assuming the other elements for misrepresentation are met, the contract is voidable and the court will permit rescission. This requires more than a mere proof that there was no intention at the time asserted and that the party did not carry out the stated intention. For example, a buyer of land tells seller that he intends to build a residence on the lot. Buyer actually intends to put up a factory. Seller's home is adjacent to the lot. Buyer lied because he knows that seller will not sell him the land otherwise, since seller's home is adjacent to it. Here, assuming other requisite elements are met, the contract is voidable by the seller because the assertion is false when it was made and it harms seller. Consider this scenario. Seller and developer discuss the sale of real property. Developer asserts that he will attempt to save an old barn on the property. Developer purchases it and later realizes it would be very expensive to save the barn, so he doesn't. Here, there would be no misrepresentation because the assertion of intention was not false when it was made, and the contract would not be voidable. The second element to fraudulent misrepresentation is that the misstatement of fact be intentionally made. An assertion is intentionally made if the maker intends his assertion to manifest assent and the maker either knows or believes that the assertion is not in accord with the facts, or does not have the confidence that he states or implies in the truth of the assertion, or knows that he does not have the basis that he states or implies for his assertion. The third element to fraudulent misrepresentation is that the other party justifiably relied on the misstatement. Under 167, this means that the misrepresentation induces a party's manifestation of assent, and it does so if it substantially contributes to their decision to manifest assent. Reliance need not solely be based on the false assertion. E.g., defendant cannot win by demonstrating that the plaintiff would have assented to the contract even without the misrepresentation. It is sufficient to avoid the contract if plaintiff weighed the assertion as one of the important factors leading him to make the contract and believed the assertion to be true. The person asserting reliance must have acted in good faith reliance on the false assertion. If the person asserting reliance failed to read documents given to him, then he cannot later complain that he relied on a contrary statement. For example, when a purchaser of a car dealership was told the inventory consisted of new cars, but the supporting papers, the receipt of which he acknowledged, clearly stated how many miles each car had been driven, then reliance on the assertion is not justified. After satisfying the elements for contractual fraudulent misrepresentation, we must make one further determination. How the fraud is carried out determines whether the contract is void or voidable. Fraudulent misrepresentation in the inducement, also referred to as fraud in the inducement, is an equitable defense which is applied when a party uses deceit or trickery to cause or induce the other party's conduct. The inducement may take the form of a party being misled about the facts and then using that information to make a decision. To make a determination of whether a fraud in the inducement exists, one must look at the surrounding circumstances that cause the wronged party to act. A contract tainted by fraud in the inducement is voidable by the wronged party. Fraudulent misrepresentation in the execution, also referred to as fraud in the execution or fraud in the factum, is a legal defense which is applied when a party deceives another party into believing the nature of a document or the subject matter of the contract is different than what it actually is. If fraud in the factum can be proven, it makes the contract void. Under the restatement, if a misrepresentation is made as to the character or essential terms of a proposed contract, which includes conduct that appears to be a manifestation of assent by one who neither knows nor has reasonable opportunity to know of the character or essential terms of the proposed contract, then their conduct is not effective as a manifestation of assent. For example, Alice and Cruella properly draw up an initial contract which both parties read and approve. Before Cruella can sign it, Alice shrewdly substitutes a different version of the contract, changing some of the terms to which Cruella has not agreed. Cruella signs the formal contract, has no knowledge that the formal contract contains terms which were not mutually agreed upon, and would not have signed it had she known of this fact. This is not an instance of fraud in the inducement because the misrepresentation does not induce Cruella to sign the formal contract. The trickery does not cause Cruella's conduct. Rather, this is an instance of fraud in the execution because Alice has deceived Cruella as to the true nature of the document. Cruella thinks she is signing a contract which contains the previously mutually agreed upon terms. Cruella has no knowledge or reasonable opportunity to know of the character or essential terms of the contract she signed because of the deceit. Thus, Cruella's signing is ineffective as a manifestation of assent and the contract is void. Non-fraudulent misrepresentation shares many of the same elements as fraudulent misrepresentation, including justifiable reliance and misstatement of fact, so the previously mentioned rules on those elements also apply here. A non-fraudulent misrepresentation takes two forms: negligent or innocent. A non-fraudulent misrepresentation is innocent when a party makes an assertion which they believe is true, but it is in fact false. A non-fraudulent misrepresentation is negligent when the party who makes the representation was careless. In addition to the negligent or innocent elements, non-fraudulent misrepresentation further requires that a misrepresentation is material. Note, to constitute fraudulent misrepresentation under tort law, unlike under contract law, a misstatement of fact must be material. Contract law requires this materiality component in cases of non-fraudulent misrepresentation. Taking Section 162, Section 2, and Section 164 together as it relates to non-fraudulent misrepresentation, we know that a wrong party will be able to avoid enforcement of a contract if and only if the misrepresentation is material. Section 162, Section 2 states that a misrepresentation is material if it would be likely to induce a reasonable person to manifest their assent, or if the maker knows that it would be likely to induce the recipient to do so. We will cover remedies more in a later chapter. However, there are some important differences of available remedies between fraudulent and non-fraudulent misrepresentations to note. For fraudulent misrepresentations, common law allows for either contract rescission to return the parties to the before contract status or contract affirmation and subsequent action for damages caused by the fraud. Common law holds the election of remedies doctrine, in which the plaintiff may either, depending on the jurisdiction, 1. Elect one of the two aforementioned remedies, rescission or affirmation with later action, or 2. To pursue both remedies, although only one type of recovery would eventually be allowed. However, the UCC rejects the election of remedies doctrine and allows for cumulative damages in which a plaintiff can both return the goods and sue for damages. The plaintiff usually must seek first damages, and if that does not make them whole again, then they may seek rescission. At common law and under the UCC, in egregious cases where the defendant has undertaken a pattern of such deceit, then punitive damages as a civil remedy are also available. Further, in such cases, the burden of plaintiff's proof is by clear, cogent, and convincing evidence, wherein the fact finder must believe the claim of fraud is very probably true. Remedies available for non-fraudulent misrepresentation are different. Common law allows the plaintiff only the remedy of rescission. The UCC allows both remedies on contracts for the sale of goods and does not require election of remedies. A review of this chapter continues in Part 2.